Ripple CEO expects SEC to lose against Ethereum, mirroring XRP lawsuit outcome. The CEO of Ripple is of the opinion that the SEC will fail in its attempt to classify Ether as a security, just as it was unsuccessful in its legal struggle against XRP. At what point will the SEC realize they will lose the war against Ether just as they lost against XRP? Asked the CEO of Ripple, reflecting on the SEC's losing badly in courts against crypto businesses. Based on reports, Ripple CEO Brad Garlinghouse believes the U.S. Securities and Exchange Commission may be looking into Ether as a potential unregistered security. Despite the lack of an official announcement, SEC Chairman Gary Gensler has repeatedly refrained from saying whether Ethereum is a security or a commodity. Most cryptocurrency tokens, with the exception of Bitcoin, are regarded as securities, as Gensler has often stated. There was a voluntary inquiry from a state authority at the Ethereum Foundation this week, according to reports, in response to a thread started by Coinbase's Zello Paul Grewal. The Ripple executive issued a statement warning investors to disregard ETH misinformation and hold off on buying spot Ether ETPs until the SEC makes a ruling. Ripple and XRP will reach a critical juncture on March 26. In regards to XRP, Ripple Labs lodged a complaint with the U.S. Securities and Exchange Commission's commission yesterday. The litigation is set to move on to the next crucial step tomorrow. The defense counsel James K. Phelan was in the spotlight on March 26. The Securities and Exchange Commission has already provided the court with its opening brief on remedies and supporting materials, despite the fact that it was sealed. In the protracted legal battle that has been ongoing for years, this is a major milestone. In the Ethereum case, the Securities and Exchange Commission is expected to face a setback due to the impending public publication of these information, as highlighted in the land statement that was sent through. In the context of the Ripple reviews, the public does not yet have access to the supporting materials and opening remedies related brief that the SEC filed under seal. The deadline for submitting the filtered public versions, as notified by Phelan, is Tuesday, March 26, 2024. The importance of the case is underscored by this date, making it noteworthy. If you want to know what to expect with Ripple and the SEC, you need to know the ins and outs of the relevant brief and how they work. An integral part of the litigation process, this document serves as the basis. The SEC explains the specific financial and legal remedies it seeks from the court against Ripple Labs in its opening remedies related brief, which is essentially the first filing filed by a party. A lot of people are waiting to see how many remedies the Securities and Exchange Commission is asking for. It will be interesting to see how much the SEC expects from institutions when they sell XRP after the legal battle starts. Our court, the district court, together with Torres, has directed Ripple to reveal its financial records for 2022 and 2023, along with the contracts for institutional sales of XRP in February. According to the SEC, these records are critical for determining an appropriate solution. This development is accompanied by Bitcoin reports. Furthermore, as per the XRP litigation, Ripple and the SEC have reached a consensus regarding the updated timeline. Information on Ripple's financial situation is both irrelevant to the lawsuit and extremely sensitive, contrary to what Ripple claims. The material in question may prove to be very important during the remedy stage of the proceedings, according to the court. To ascertain the scope and character of the appropriate sanctions and remedies, the Securities and Exchange Commission maintained in its motion that access to the firm's financial records is necessary. Only recently did Ripple Labs and the SEC provide a detailed schedule for the remedies phase to the Southern District Court of New York. This agenda details the steps to be taken in order to seal and redact court records that are pertinent to the remedies phase of the action. This is a crucial part of the process that will determine the financial and legal ramifications for Ripple Labs. Many significant developments have transpired within the course of the continuing legal battle between Ripple Labs and the U.S. Securities and Exchange Commission. The opening remedy brief and accompanying materials from the Securities and Exchange Commission have been submitted. I will remain discreet. These changes are the latest in a series of decisions that have piqued the curiosity of the Bitcoin company among the various legal actions. The censored documents will reveal the suggested remedies stance against Ripple Labs and will be accessible to the public after the seals have been removed. Notable XRP attorney James K. Phelan made the announcement in a post she posted on X. Phelan claims that the SEC and Ripple Labs have agreed upon a date for the public publication of these materials. On March 25, they will meet to discuss the required redactions. In the following week, on March 26, they will submit a redacted version to the public docket. In order to protect sensitive information while keeping the public informed, this step is in accordance with the sealing request that was launched earlier this week. Ripple will submit a sealed objection in April. Both parties have established a clear and concise protocol for omitting and filing these papers. Ripple Labs will submit its challenge the following month after the SEC makes their initial submission. More specifically, XRP will secretly submit its opposition on April 22nd. The process is very similar to this one. A public version of the resistance will be submitted by April 24th after the parties meet the following day to decide the necessary redactions. While this rigorous procedure ensures the continued preservation of sensitive material, it also ensures that everyone as well as others will have access to the reasoning and methods contained within this important decision. Securities and Exchange Commission officials also plan to use the same filing format to address Ripple's concerns. We will make the necessary edits on May 7 and submit the revised document by May 8. This is subsequent to the May 6th when the paper was filed under seal. These steps show how important it is to keep certain parts of the case under wraps, like the contracts and financial data linked to Ripple's institutional XRP sales and the complaint that was submitted after 2020. The potential was brought up by experts, the risk of sex penalties for Ripple. In what the SEC saw as a breach of securities laws, Ripple was accused of selling XRP to institutional clients for $770 without properly documenting the transaction. The battle in court had just begun. Rumor has it that Ripple would face heavy fines as a consequence of the current remedies phase, which would be devastating for the cryptocurrency. Transactions involving Ripple's on-demand liquidity are considered to be securities. Disciplinary action of up to $3 billion possible in this case. However, the amount of the potential fine is subject to a range of predictions. The fines may not be as severe as the anticipated $200 billion in legal bills for Ripple, which may also affect the company's finances. According to some, the Bitcoin market is not immune to the effects of this move. The findings might set new parameters for how digital assets are defined and regulated under U.S. securities legislation. Meanwhile, as the parties get ready to submit their redacted documents, stakeholders, both inside and outside the Bitcoin industry, are waiting for further findings. There must be a careful balance struck between protecting sensitive information and ensuring transparency in high-stakes court conflicts, as shown by the meticulous suppression and public disclosure procedure. The market will be interested in hearing the arguments put forth by the Securities and Exchange Commission regarding a severe penalty for violations of Section 5 of the 1933 Securities Act. The selling of unregistered securities to institutional investors by Ripple in July 2023 was determined by Judge Torres to be a violation of the Securities Act.